And before I go on to the fundamental principles, I want to stress another theme. I've talked about the emergence of private actors, the development of new uses of outer space. And I want to, on the legal side, stress this theme, that space law is multi-dimensional. It is complicated. It is challenging, and that's what makes it fun. That's what makes it interesting, and that's what makes it an excellent career choice for a young lawyer. And it's multidimensional in this way. First of all, it's very broad. What is space law? It can be anything from laws of war governing the military use of outer space to safety regulations for private suborbital space tourists and everything in between. It could deal with the criminal law for crimes committed on the International Space Station, or it could deal with immigration law on the surface of Mars. So the subject matter is extremely diverse and multidimensional in that respect. But space law is also multidimensional in the fact that it exists on the international level, the regional level, for example, the European Space Agency and its governing documents and laws, which governs the region of Europe. It's domestic, that is by country. The US has, under Title 51 of the United States Code, voluminous laws on the use of outer space, and then attendant regulations that implement those laws in the Code of Federal Regulations. So there are a lot of domestic laws on the federal level, and then even state laws. So on the lowest level, for example, there are states in the United States that have tried to attract Virgin Galactic and other suborbital space tourism companies to their states, to their state spaceports, which have been growing in number around the country, trying to attract these companies by passing laws that eliminate those companies' liability in the event of an accident. So if someone is harmed or killed, if something goes awry when Virgin Galactic flies its private space plane into suborbital space, these private laws, these state laws, eliminate liability. Now we can debate whether that's a good or a bad thing, but that's an example of space law. So multidimensionality is an issue. What are some of the fundamental principles? Let me talk to you a little bit about that before we get into, I think, the most interesting part of the presentation, and where I hope a lot of the questions go, so that we can even hear, you and I together, make some progress in resolving the most challenging issues of space law. But let's get first to some of the basic concepts. What is space law? And I'm drawing these concepts from the Outer Space Treaty. There are 5 multilateral space treaties that have been drafted in the United Nations, all of them in the 60s and 70s. There hasn't been a major space treaty since 1979, but it's the Outer Space Treaty, as I mentioned, the Magna Carta, which sets out the basic principles of space law. And then we have the Convention on the Rescue and Return of Astronauts. We have a convention on liability. We have a treaty on the registration of space objects so that we all know what is where. And then finally, we have the Moon Agreement, which details additional and more specific rules with respect to lunar activity. However, that 5th and final multilateral treaty from the 60s and 70s is largely seen as a failed treaty because it has not been signed by the major space powers. So we have 4 really critical space treaties that define international space law. And one of the fundamental principles is that space is to be used exclusively for peaceful purposes. And that, and part of that is a prohibition on the stationing of weapons of mass destruction, thinking of nuclear weapons, in orbit. It's illegal for any country to station a nuclear weapon in orbit. And this points out one of the opportunities of space law. the opportunity to remake society in a better image, to leave behind on Earth the frailties and the flaws of our history and our baser human tendencies, to make a better world. And that is what is attempted in the Outer Space Treaty by prohibiting nuclear weapons in orbit. Now, it doesn't mean that military vehicles are not allowed whatsoever in space. The space is still used heavily by the military in an ever-expanding way. Militaries around the world rely on space-based infrastructure, on photographs of their enemies' military installations from satellites, of the telecommunication systems, to satellite-guided bombs. So the use of outer space by the military is very much a reality. But the rule is that there are no nuclear weapons in orbit, and that all activities, even military activities, it may sound contradictory, but even military activities must be carried out for a peaceful purpose. Space use shall be used exclusively for peaceful purposes. What does that mean? You can still have military active and make use of satellites and be active in space, but it can only be used for the peaceful purpose of self-defense and not for aggressive purposes. So peaceful purposes. The Death Star, I get this question on a regular basis. Would it be legal for the United States or another country to construct the Death Star, a artificial planet that has the ability to destroy real planets with its mega laser? Well, you would not be able to station that in orbit because that's certainly a weapon of mass destruction. So you wouldn't be able to put it into orbit of the Earth as a second moon, an artificial moon. But you would be able to build it out in deep space as long as it was used exclusively for peaceful purposes, that is, self-defense. Here's another fundamental principle, that is the freedom of use. It's one of the things that distinguishes space law from other areas of law, such as aviation law, is that you can fly freely over the territory of another country. You don't need the consent of another country, unlike air law, where if you fly a plane over another country, you need their prior consent. Not true. So everyone is free to go anywhere in outer space, and you don't need the permission of another country to go anywhere. But balancing that is that, yes, you're free to go to the moon, everyone is, but no country is allowed to appropriate it in any manner. So when we had the picture of Buzz Aldrin planting a flag in the moon, he did not claim it as the 51st state, and it would have been illegal under the Outer Space Treaty. It was simply as a gesture that we have arrived, but we have arrived in peace for all of humanity. You cannot claim any celestial body. It cannot become a new province of China, for example. What about liability? The Outer Space Treaty, coupled with the Liability Convention, which came a few years after, establishes liability. Strict liability. That means without any defenses for any damage caused on the surface of the Earth or to an airplane in flight by a space object. So if a satellite re-enters, the atmosphere, I believe I have a picture here, and we have spacecraft re-enter the atmosphere on a regular basis. If a component crashes on the Earth and causes damage, injury, death, damage to property, the launching state is strictly liable. Now, and here we have a graphic of the breakup of the Tiangong, the Chinese space station, which happened not long ago. Most of things that re-enter vaporize in the atmosphere, but we do have pieces that survive re-entry. What about if damage is caused in outer space? Here we have a portion of a part of a space shuttle that has been hit by a piece of space debris traveling at 17,000 miles an hour. And it can be minuscule. It could be like the grain of sand, and it still can break right through a panel of steel. So damage caused in orbit, in space, will enable you to impose liability on the launching state, but only if they're at fault. And that is a question of debate. What does it mean to be at fault when conducting a damaging space activity? Now here we have a few other basic concepts. That is that all states are required to authorize and continually supervise private activities. And that is the basis for national regulation, and why we have so many domestic regulations is that international law requires it. And the United States has a very robust private space industry. We have a lot of space activity being conducted by private individuals and companies. And so we have a lot of regulations, and that's required by international law. It's also required that you register your space objects so that everyone knows it's a public registry operated by the UN, and it's publicly searchable. You can go online right now and search what's in orbit. There's an obligation to rescue and return astronauts. If a space plane goes off course, all countries are required to make efforts, reasonable efforts to rescue them, and must return them to the launching state. And these are two of these last two are among the most important and the most controversial in today's lunar landscape, space legal landscape. And that is that everyone is required to operate with due regard for the interests of others. You need to consider what others are doing in space and operate with deference, with due regard. And hand in hand with that is the requirement that you not cause harmful interference. Everyone is free to use outer space, but we shall not interfere with each other, and we shall take into consideration everyone's interests. Now, what exactly that means is to be debated. Although I don't have it listed here, I should mention one other fundamental principle, and in fact, it should have been mentioned right at the outset, is that all space activity must be conducted for the benefit of all humankind, the benefit of all countries, regardless of their state of political or financial development. And the meaning of that is very much in debate right now. Does that mean that if you harvest $1 trillion worth of platinum from an asteroid, that it must be shared for the benefit of all countries equally? Well, we don't share profits that are made by telecommunications companies, so I think that will not be the winning interpretation. But those words do mean something. There's no surplusage in international treaties. Every word means something. So what does that mean? It's often viewed as really that we give opportunities for inclusion and partnership, that we share data and science that is discovered in space. But does it mean something more?